Okay, let's go ahead and get started. Welcome, everybody. Hello, and thank you for joining us for today's webinar on facial recognition, location data, and biometrics. My name is Abby Gruwell. I work in NCSL's DC office on federal privacy and technology issues. This session is part of Privacy Week, the first event of the new NCSL Privacy Working Group, which is a subcommittee of NCSL's Cybersecurity Task Force. The work group was recently formed to examine policy issues related to consumer data privacy, algorithms and artificial intelligence, government data usage, transparency, and other issues, as well as to consider the intersection between data privacy and cybersecurity. We are grateful to our Privacy Working Group sponsors for their support of these activities. Over the next 60 minutes, we encourage your participation, so please feel free to type your questions into the chat box. This webinar is being recorded and will be made available on the NCSL website within about a week. With that, we'll turn to our topic of the day. Facial recognition and other biometric technologies are rapidly proliferating in consumer and government applications, presenting new and challenging privacy issues. State legislatures are responding with calls for regulations, including moratoria on the use of facial recognition. This session will discuss the many ways biometrics are being deployed and proposals for regulating them. We are pleased to have with us today two distinguished speakers, Claire Garvey from the Center on Privacy and Technology at Georgetown University Law, and Chris Koopman from the Center for Growth and Opportunity at Utah State University. We have made further resources on this topic available on the Privacy Week website. We will hear first from Claire Garvey. Claire is a senior associate with the Center on Privacy and Technology at Georgetown Law. She was the lead author on the Perpetual Lineup on Regulated Police Face Recognition in America in 2016 and 2 follow-up reports. In 2019, she testified before the House Oversight Committee about police use of facial recognition. Her commentary has appeared in the New York Times, the Washington Post, the Wall Street Journal, and she serves as an expert resource to both Democrats and Republicans in Congress and state legislatures. She received her JD from Georgetown Law and her BA from Barnard College. Claire, I'll turn it over to you.
Great, thanks so much. I'm very much looking forward to the questions, so I'm going to keep this pretty short. Basically, I want to give a very brief overview of the state of play of face recognition use in law enforcement, which I think it's the area that I focus on in my research, and I think is probably the area that's most focused on in state legislators today, or state legislatures. So face recognition used by law enforcement is incredibly prevalent. Back in 2016, we estimated that about a quarter of all law enforcement agencies had access to a face recognition system. These were agencies that we could confirm. So the number is likely much higher. In addition, thanks to the ever increasing access to driver's license databases, over half of all American adults are in a face recognition database that's used for criminal investigations. And the recent efforts over the last year and a half or so by a number of state and local jurisdictions notwithstanding, it is still a largely unregulated field. This field is governed by policies. Sometimes other agencies don't even have policies governing how and when they can use this technology. And transparency still is a huge problem when it comes to understanding the scope and the types of uses that we see this technology in. 3 things that I want to just quickly focus on in terms of the concerns that face recognition raises. I realize this is a pretty high level discussion, so I'm not going to go into too granular detail. But the first is that face recognition is unique in that it facilitates biometric surveillance. It's the first modality, biometric modality that we have that's technologically feasible and both widely implementable, that enables the remote secret identification of groups of people, which raises implications for the First Amendment, the chilling of free speech, assembly, and protest, and the Fourth Amendment, the ability to track somebody's movements across time and space, depending on where their face shows up in public. That latter category, we have not seen real use cases in the United States. The use of face recognition to track individuals, but we have seen face recognition used on public protest, and a growing concern that that is in fact chilling people's willingness and ability to participate in particularly contentious or law enforcement focused protest. So this idea of biometric surveillance. One of the reasons why this has been made incredibly, that the the implementation of face recognition has been so rapid is the existence of legacy databases. Photo databases essentially can be converted to biometric templates very quickly. And most, if not all of us, have biometric or face photographs on file with one or more government agencies. Think passports, visas, driver's licenses, mugshots, etc. And the other is legacy camera systems. CCTV systems can, to a greater or lesser degree, be mobilized to facilitate biometric identification by connecting face recognition directly to live video streams or using static one-off images from CCTV camera feeds to conduct that identification as well. The second issue is face recognition as an evidentiary tool. This is a forensic identification tool, and that is how it's predominantly used in the US in the law enforcement capacity. It uses a forensic identification technique, somewhat akin to latent fingerprint identification, where a latent face print, if you will, is left at the scene or on a camera and can be run against the face database on file to generate a possible match. This raises some questions about misidentification. There are a lot of variabilities in how these systems are run, and a lot of this variability leads to a risk of misidentification. As it stands now, I think there's a very good argument to say that under the Fifth Amendment, under the right to due process, the defense must have access to information about face recognition searches, but we're not seeing that. Face recognition has been used in criminal investigations for about 19 years in the United States, and it's incredibly rare that the defense actually has access to information about how these searches are run and what risk of misidentification was actually presented by how that was run. And then the last issue is one that comes up a lot with face recognition in the press, and that's the disproportionate impact of the use of face recognition on communities of color and the risk of racial bias. Studies consistently show that, with a few exceptions, face recognition systems do seem to perform differently depending on the race, sex, and age of the person being searched, which raises questions about equal protection under the law and the risk that misidentifications may happen more in communities that are also over-policed, primarily Black and Brown communities in this country. In terms of legislative approaches, over the last 2 years, we've seen a lot of efforts to, at the state and local level predominantly, but also a few proposals at the federal level to rein in the use of the technology, either through bans, moratoria, or regulations. In one of the resources you should have available to you is a taxonomy of legislative approaches that we've seen in the US to date, written by me and a colleague of mine, Jameson Spivak. We identified 4 different approaches so far. All-out bans, basically saying face recognition cannot be used either at all in a given city or by law enforcement or by city officials, that type of thing. Time-bound moratoria, basically saying we're going to press pause on the use of this technology for a certain period of time, after which it will either continue as it was beforehand, or during that interim period, we will have set rules in place to constrain or regulate the technology. Directive moratoria, which basically says face recognition cannot be used unless certain conditions are put in place, such as regulation or audits, that type of thing. This sounds a lot like bans because, let's be honest, a ban is a time-bound or a directive moratoria that can be repealed at any point in time. It would take affirmative action on the part of the legislature. And then finally, the most common approach is regulation. At any sort of area of the spectrum, from sort of very light touch regulation, maybe just requiring transparency and reports to Congress, or more heavy-handed regulation requiring, let's say, a court order prior to the use of the technology. Those are very, very broad strokes as the outlining the available approaches. Within the regulation, there are any number of ways to approach this. My overarching recommendation here is to approach it not from a technology-specific perspective, but from what rights and civil rights and civil liberties are being affected by the technology. Free speech, Fourth Amendment, the right to privacy, due process, the right to a fair trial, the right to access to information that speaks to your guilt or innocence, equal protection. The reason for this is that face recognition is very in vogue right now. Gait recognition might be a thing that we have in 5 years, or face recognition may morph into, with really high quality cameras, iris detection. So the more narrow, the more focused we are on the particular technology, the less future-proof it is. And I think the less it actually gets at the real concerns, which are the impacts on rights and liberties. So I'm going to leave it there, and I'm really looking forward to the discussion.
Thank you so much, Claire. Next up, we have Chris Koopman. Chris is the Executive Director at the Center for Growth and Opportunity at Utah State University. He specializes in regulation, competition, and innovation. His research and commentary has appeared in the Wall Street Journal, New York Times, Washington Post, USA Today, Bloomberg, and NPR. He is also a contributor at The Hill and was named to Forbes 30 Under 30 2016 for Law and Policy. Prior to joining the Center for Growth and Opportunity, he was a senior research fellow at the director of the Technology Policy Program at the Mercatus Center at George Mason University. He is currently a senior affiliated scholar with the Mercatus Center and a member of the IT and Emerging Technology Working Group at the Federalist Society's Regulatory Transparency Project. I'll turn it over to you, Chris.
Awesome. Thank you so much, Abby. And thank you, Claire, for outlining a lot of the concerns that I think many of us have around the law enforcement use of biometric data and facial recognition technology. One of the things I want to highlight, now I'll go through 3 parts here, is sort of following up on some of the law enforcement concerns that Claire raised, dive in a little bit into the current state of the rate. What do the laws in states that have passed them? Currently, there's only about a half dozen laws passed in the United States that regulate biometric information. And then jump in and talk a little bit about the impact that these laws are having, but I'm also going to bring up some commercial applications as well. And I want to really bring to life something Claire had mentioned, and that is the sort of the rights violating abuses and risks that can come along with the misuse of biometric data. And I want to talk specifically about a young man named Michael Ustry. So Michael is a filmmaker in Louisiana, and somehow got himself tied up into a nearly 25-year-old cold case murder in Idaho Falls, Idaho, because his father had uploaded his biometric data in the form of his DNA to Ancestry.com. Not technically to Ancestry.com, to another project that was purchased later by Ancestry.com. But law enforcement, when they realized that they had wrongly convicted the murderer, 20 years ago, and reopened the case, and there was some increased attention on these familial searches, using DNA to find the killer or the murderer or the rapist or the criminal based on familial DNA. So you can say, I have this person's DNA and we know it's a distant cousin. So let's go through the entire family until we find the suspect. And that's exactly what happened in this case. And Michael Ustry Jr. was identified both because his father uploaded the data, they mapped 5 generations of the Ustry family, and then found Michael Ustry Jr., who had actually been in Idaho Falls at some point in his travel in his life, had lined up to a degree with the events that had transpired 20 some odd years earlier. Long story short, it turns out he was not the murderer. He was not the suspect. He was not involved at all. They ended up finding the correct suspect later, but Michael Ustry had to spend months of his life defending himself and protecting his name and his freedom because of sloppy police work on the part of Idaho investigators as they were trying to tie up a cold case. That is a tragedy. Using this type of data in that way is a tragedy, and we should limit this. But we also, for all of us on the call, we also need to differentiate the law enforcement misuse of this technology from the promising commercial applications as well. And I think that many of the laws in the states as written focus almost exclusively on the commercial applications and do not really limit the law enforcement applications in many degrees. And I think the Biometric Information Privacy Act in Illinois, which was the first one passed and has been a model for the half dozen states that have since passed these laws does exactly that. It limits the commercial application, does nothing for the types of rights violating uses that Claire has mentioned. And I think an interesting thing just to dive into Illinois, as we'll just talk about Illinois, Texas, Washington, New York, Arkansas, and California through CCPA all have biometric laws on the books now. But Illinois has been the model for the most part. It was passed in 2008. And there's something interesting that Claire mentioned, and it's worth saying about what's the best way to put this? The broad scope that these laws take, that they're regulating technology that hasn't come into existence yet. Claire mentioned that maybe in 5 years, we'll have gait recognition technology in like broad use. Illinois included that in its biometric privacy law passed 12 years ago. So they were regulating technology almost 2 decades before that technology is even being used. To give you context for Illinois' time on this, Illinois passed the Biometric Privacy Act in 2008, about 8 months after the first iPhone came out. So think of how far technology has come just in the phones that all of you probably have on this call. And Illinois' law has not changed. It's been the exact same since 2008, has more or less defined biometric privacy in the exact same way. The fines, the fees, the requirements, the requiring clear and written policies and advanced disclosure and written releases, all of this has remained the same, but our technology has changed. And that's a really important point for people on the call to take into account. So why should the law take into account changes in technology and ensure that we aren't sort of stifling these extremely promising technologies from coming to fruition? I think let's dive into some of the technology here. How is biometric and facial recognition being used commercially? You think Microsoft Seeing AI is an example. Microsoft is literally giving sight to the blind through facial recognition technology. There are auto manufacturers who are generating biometric sensors to identify drowsy and distracted drivers. And these can also detect mood, right? They can detect scowls on your face. They can see if you're getting increasingly unhappy sitting in traffic, and they can do things like change the music, adjust the lighting, avoid annoying bells to maybe not send someone into a road rage instance. And then finally, Aibo from Sony, which is a robot pet that can provide companionship without care. And why is this important? There are actually studies that show that this can be a key complement to dementia care. So having a companion in the house in the form of a pet that can identify a person's mood, can recognize their face, can interact with them in a way that would provide this ongoing companionship is key in dementia care. All 3 of these technologies cannot be deployed in Illinois and are not being deployed in Illinois. You think actually Sony does not sell their robot dog in Illinois because the law requires that advanced disclosure and written releases be collected from every single person in which their biometric data is collected and processed. So let's say you have a person who is in dementia care and has a robot dog, you'd have to have an advanced disclosure and a written release from every person in which that dog interacts. So every person that walks into that person's home, their apartment, whatever, would need to have a written release that says, I allow myself to be processed by Sony's technology, or it's a violation. And this isn't just hypothetical, this is really what's happening. You think earlier this year, Facebook settled a $650 million lawsuit. It was actually in the billions. They settled for $650 million based on the facial recognition technology within their app, right? Basically, a class action lawsuit transpired in which users said that they didn't actively consent and were not given advanced disclosure and did not submit written releases for Facebook to process their biometric data. And this is just the facial recognition technology in the app that says like, hey, here's this picture that you just uploaded. Would you like to tag these people that we think you may have just uploaded your picture with? Or when someone uploads a picture of you, they can notify you and say, hey, so-and-so may have just uploaded a picture of you. Would you like to know? That's turned off. It's an opt-out for everyone in Illinois now. And actually the company is working on geofencing the state in the same way that many other apps have been geofenced where they're illegal. So if you're driving through Illinois, they're actually turning features off when you enter the state. This is the same thing going on with Apple and its Photos app. And even this has gone to so far as time clock vendors in Illinois and in Texas have been sued based on the thumbprint time clocks that they've sold to employers. So the classic punch clock is a card into the clock and it times you in and out. The technology exists now to use your thumbprint so you can sign in and out, and your employer can ensure that no one is punching you in and out, that it is in fact you punching in and out. These companies are now being sued, right? Because they provided the technology, and the vendor, not the person deploying the technology, but the vendor. These are broad sweeping regulations and limitations that are sort of prohibiting the advancement of this technology. And the second part, and I think this plays off of what Claire was talking about, is in many states, there is not clear guidance, regulation, and restrictions across the country for the law enforcement use of this technology. So in instances where you've banned the commercial use and you've sort of let the law enforcement use go unfettered, you've created what economists would call a monopsony, right? We all hear these days in technology about monopolies, but on the other side, there's something called a monopsony, which is it's a market with a single buyer who has a power to shape the market based on what they're purchasing. And in some instances, this is exactly what these laws are doing unintentionally, is they're creating a monopsony where the legislation was passed for fear of the abuse, but they've created a situation in which the only institutions that can use it are the law enforcement institutions. So you will only see law enforcement applications of this technology. And that's not to say also that there aren't rights enhancing uses of this technology as well. I mean, you think the Innocence Project for a very long time has been using almost exclusively biometric data in the form of DNA evidence to clear the wrongly convicted. And I would also say that even on the border, we've seen instances, in DHS earlier this month just announced regulations to update its own biometric regulations that would limit the need for family separation. I think we've heard a lot about family separation at the border because they cannot identify if an adult bringing a child over the southern border is in fact the parent of that child or a family member of that child. And DHS right now under its regulations are limited in the way that it can collect biometric data from minors at the border. And so it almost creates this instance in which the only option DHS seems to think it has is family separation. And yet that's just one instance of collecting biometrics. You could quickly identify parents and children, or at least familial connections that would allow you to protect the rights of those parents, keep nuclear families together, and really enhance the rights of people at our southern border. I think that's probably as far as I want to go before we get into Q&As, but I would say for those of you in the room, just three things to consider when contemplating these policies is identifying the nature of the problem very, very clearly, identifying the nature of the problem, narrowly tailoring your regulations or your legislation to fit that problem, and then be willing to admit when the law doesn't work, right? When the world changes, the technology changes, or there are unintended consequences, be willing to very quickly and humbly change those things to continue to balance the really promising technologies that we see with the fears that we do have, and legitimate fears about the rights violating uses that they may have for individuals and communities.
All right, thank you very much, Chris. We appreciate your presentation, and we might need to come back to robot pets because that sounds adorable, but we're going to move into the question answer part of our program today. We have some questions prepared, but please enter your questions into the chat box. First, I think both of you set this up really well. How has the commercial and law enforcement use of facial recognition evolved over the past few years, and how do you see it evolving in the future?
I'm happy to start on that. I mean, we're seeing face recognition, I mean, I highlighted the idea that this is the first sort of instance of biometric surveillance that raises a lot of both opportunity and risks on the part of various users, both commercial and law enforcement. And Chris and I might have a little bit of disagreement or maybe like a difference in optimism on the commercial applications of face recognition. I focus a lot on its use as to detect known or suspected shoplifters, for example, where there's actually no sort of process by which you can actually challenge being kicked out of a store on the basis of being enrolled or misidentified as being enrolled on a face recognition list, or other applications of the technology, like the use in Clearview AI of scraping the internet essentially and enrolling 3 billion images into a face recognition system that was initially available to places like Macy's and JP Morgan and are now only available to law enforcement, to Chris's point, where we're narrowing the field based on this risk, or this perceived risk on the commercial side as opposed to the law enforcement side. The way I see face recognition, the few sort of areas for growth are basically a scale concept. However many cameras there are, we could just see an increase in application there. I think we're going to see new modalities of biometrics come online. Voice recognition is probably the next one, based on the prevalence of legacy databases from the Department of Corrections in various places that record and tag phone calls that inmates receive based on the identity of the caller and of the inmate. With gait recognition, there aren't the legacy databases, so there are a few more hurdles for widespread iris, gait, or let's say ear pattern analysis to come on deck. Another field I think related, and something that Chris touched on, is this idea of sentiment analysis or face analysis, trying to determine somebody's emotional state based on their facial expression. There are a number of challenges with this, and the science is pretty shaky at this point on whether or not this is something that whether our faces accurately portray our emotional state, such as anger, surprise, happiness, intent to deceive. There's a company called Faceception out there which purports to be able to identify the propensity of somebody to commit a certain type of crime based on the structure of their face. The CEO has acknowledged that there's no science behind that particular application. That has not stopped the technology from being sold and deployed in at least 2 countries in the world. So I do think emotion detection and sentiment analysis is incredibly appealing, and we're going to see a push towards that. Think the idea of like remote lie detecting. TSA is interested in frictionless security. They would have to build in some sort of lie detection, sentiment analysis, emotion analysis into that. They've talked at length about that. And then, yeah, I mean, I think I'll leave it there. It's an interesting field because it's really, it's open to the imagination. And one thing I would leave you all with is that the technological capabilities and the science does not necessarily drive or lead, and the technology or the deployment follows. It's often the deployment of the technology that happens before we've actually thought through the science. Like, for example, like the forensic science behind the use of face recognition in criminal investigations, the science behind being able to detect someone's propensity to be a pedophile or a terrorist based on the structure of their face. The science isn't there yet, but the technology is. So we do see that very strange, pretty concerning concept happen in the biometrics field, and I think we'll continue to see that.
So I will start backwards, and this wasn't framed as a debate. I think there are areas where we disagree. There are also areas where we clearly disagree, and I think it's worth sort of, it makes for a more interesting conversation to focus on that. And I do think I'll work backwards. I think what you're talking about in terms of the science following deployment, right? Like the deploy and then learn and then iterate. That's the process of innovation. And I think it's one thing if my car thinks that I'm frustrated and changes mood lighting and plays Kenny G, and I don't like it, and then I take it to the dealer and say, turn it off, versus using that same technology to try to identify someone who may or may not be lying when they might just have a you know, if, you know, it would be like trying to determine if I'm unsure or not while I'm talking and then say, well, he's lying because he looks unsure, right? Or he quick twitch in his left eye means he lied, right? And the computer says this. It's one thing when it's used in a commercial aspect and I'm able to have a relationship with that company or choose not to use that company. It's another thing when it's used in a law enforcement aspect and I have no choice of provider of law enforcement. And I do think that is a really, really important differentiation to make in this space, in that, like, you know, for example, my Google Photos is convinced that my 6-month-old and I are the same person when I'm cleanly shaven. And it's not wrong, right? Like, we look somewhat alike, and it's not, it's funny. And you just correct it, right? You can tell it, and it does something different. That is to me, that is how innovation works. That's how this process should work. That's how we improve our technology. And it's also why government should be a first mover or a last mover, not a first mover in this space. You know, you can have like bad facial recognition that doesn't hurt anyone. And in fact, I would even say the shoplifting example that you give, Claire, is a clear one in which if there are particular people or even, let's say, communities that are disproportionately affected by the technology that says they are a shoplifter or is it confusing them with one another, it's very easy for those people to exercise voice and to tell the grocery store, the gas station, any of these other, we are very unhappy with the way that you are deploying this technology in our community. And they do have some say in this. You see commercial boycotts work all the time in how technology is used by corporations. And I would say that isn't really a rights violating use of that technology. It's bad business, but it's not putting someone in jail or threatening their life and their liberty. And I would say keeping those things very separate in terms of like commercial and government use. And let's focus on those things, build the protections and the barriers around the law enforcement and government use of this technology. I mean, Illinois focuses solely on commercial use. You have states like Maryland over the past several years have proposed bills that would focus exclusively on the law enforcement use. I would encourage you to look at proposals in states like Maryland, where you've had bills that have died in session that do provide those rights violating protections, right? In instances where this technology may in fact put someone's life or liberty in jeopardy, there are clear uses, time limitations. You cannot just like scan everyone all the time. Those are things that should be looked at in terms of law enforcement uses. But I would say conflating commercial and government uses of this technology sort of does what I said before, limits the commercial use and limits, as you say, Claire, you need to use the technology to make it better. Limiting the use of the technology puts us in a stagnation where it won't get better, and exactly what we have is what we will have forever. And we can't use the same technology in the way that DNA has been used to actually get people their liberty when they've been wrongly convicted or accused. So in some ways, the commercial aspect is an extremely important part of the law enforcement aspect, in as much as improving the technology will ensure that some of the very early uses of this technology do not continue to be used in the way that they have been.
Claire, did you want to respond to anything?
Just a quick response, and it ties in the comment from Joseph Jerome about how would commercial boycotts work in light of how little transparency there's around face recognition. I think that is one of the problems. The idea that there is agency is really only to the extent that individuals know that they're being kicked out of a store because of face recognition misidentification. And that's not necessarily the case. There aren't requirements of transparency. It maybe says like, smile, you're on camera, but you might not know why there's like a security guard shadowing you around. You may just assume that's because you're a young Black person in this country and not because you've been misidentified as a potential shoplifter. The other point I would say, I wholeheartedly agree that law enforcement and commercial applications are very distinct, and there's every reason to treat them differently. I do think it's not always the case that a commercial use of the technology is consumer facing. So one of the areas where we see sentiment analysis come into play right now is with hiring applications. And maybe I go through a first round of screening for hiring, and the algorithm identifies that I raise my eyebrows a lot. And so it thinks that I am not confident, or I am like a psychopath. Who knows? I don't know what raising your eyebrows means, but it flags me as that. I may, again, not know that that was used, but also not have any recourse to say, I was denied a job or denied a second interview because the algorithm doesn't like, or has a weird bias around my mannerisms from a racial, ethnic, or gender perspective. So I think it's not quite black and white on that, but fair point that it is interesting that we've seen this focus on commercial and less on law enforcement, even though the law enforcement applications are incredibly prevalent and directly speak to our constitutional rights.
And I would just add, so to the instance, like you could come up with two hypotheticals in a 7-Eleven. Let's just use a convenience store. Someone walks in. The mode of identification, right? Doesn't necessarily matter. If the person walks in, the camera says, this looks like someone that has shoplifted in here before, and tells the clerk, and the clerk is like, oh my gosh, I recognize him, get him out, versus the clerk saying, you look like someone that walked in here before, I'm kicking you out, right? In both instances, the mode of identification is essentially the same. Like, I looked at your face. The other one, I would say, it has the tendency to probably be more accurate, right? You and I both know, right? Most people on the call would probably know human memory is like really, really bad, right? Like, identifying faces of strangers is bad, right? There's tons of evidence on this in terms of not just constructed memories, but like just completely bad memories. In some ways, this could limit those instances that are already happening, where individuals are kicking people out of their stores. They say, don't come in here. I know you. I know your friends. Get out of here. Versus, an instance of a person stopping and thinking before they make the decision because they didn't get flagged by the facial recognition technology. So again, I think there are things to balance here. And again, if a store clerk is kicking members of the local community out of the neighborhood, whether he used a computer or his own eyeballs, there's going to be a very, I think, clear backlash in the community with regard to the decision being made by that clerk, be it the owner, the user, whatever, right? Like, I think most people in the community would be frustrated. And that's what I mean when I say like commercial boycotts. Even if there's no transparency as the decision, everybody would know the decision was made. Like, Jimmy was kicked out of the neighborhood store, and now we're all mad about it. Whether or not it was technology-based or human-based, it probably shouldn't matter, right?
All right, well, we have a question from the audience. Do you have thoughts on technology known as deepfake, giving abilities to modify video or faces to put words in someone's mouth? How should legislators possibly think about limiting its misuse, as it's currently used often for fun?
I can jump in. I do not know that there is a clear reason why something like a deepfake needs to be legislated. I think that there are plenty of torts that would cover how one person may use a deepfake to affect the personal or commercial standing of another person, and that could be remedied very easily in courts. I think this is a perfect example of how legislators should sort of take a stop and wait and evaluate the situation before jumping in, because you may end up regulating something away that really didn't necessarily need to, but open open the doors for something else. I think a perfect example of this is BIPA, the Biometric Information Privacy Act in Illinois. Over a 24-month span, you had hundreds, right? From 2018 to 2019, it was something like 200 cases filed in Illinois just on the BIPA Act and claimed violations of the BIPA Act, because it was written 10 years prior. The technology has dramatically changed, and now there are all these very clear applications of the law to uses of technology that were never intended or thought through, that have created all kinds of troubles in the courts for this. So that would be my take on deepfakes.
One thing, this is honestly not my area of focus, so I don't want to speak too much to it, but I do know from my work with defense attorneys, there is one of the concerns that the idea of deepfakes raises is, in the court system, video-based evidence is considered sort of the gold standard of evidence, that it's pretty much unimpeachable. Deepfakes raises a question about whether we can continue to assume that, or whether video evidence, as introduced in court in civil and criminal cases, may start being subject to question on the basis of deepfakes. I'm not saying it may not need a legislative solution. It's just going to need some sort of very careful, very intentional approach on the basis of courts to not continue assuming that video is unimpeachable if it in fact can be convincingly modified.
So one of the interesting things about biometric technology is that it can be used in a lot of different ways. Can you talk about how legislators should think differently between aggregate or population level data collection versus targeted collection that just goes after one specific person? Are there differences in how they should consider policymaking?
I'll take a stab at this from a law enforcement perspective. I would make a distinction between, and I think we're talking about the collection of what would be called probe photos or probe video, the video of the unknown individual that law enforcement is seeking to identify. The existence of the database is already established. So the distinction I would make is that with individual collection, when you're looking at a specific individual, you can establish reasonable suspicion or the nexus of that individual to the crime that you're investigating. Right now, very few, but some jurisdictions do have restrictions around who can be searched. A law enforcement official cannot just search his ex-girlfriend's new boyfriend, but in fact hopefully needs a criminal nexus. And he might actually be limited to searching for the perpetrator of a crime, maybe the victim, and possibly a witness as well, although some jurisdictions have limited the witness component. That individuality and nexus to the crime can be established with sort of mass collection. One would think with, let's say, real-time face surveillance off of video feeds, you don't have that same, well, you can sort of narrow down who you're searching for and narrow down the repercussions of misidentifications by specifying who's on the watch list, who is able to be identified. But the risk of misidentification and then sort of adverse action taken against individuals on the basis of a misid becomes there's a high risk here, because sort of mass surveillance, biometric surveillance, is going to be the least accurate form of face recognition. The cameras are not well placed. They're usually above our heads. We're not facing the cameras. We're not doing sort of intentional collection. There's low quality image inputs, et cetera. That's all going to degrade the accuracy of these systems. And the consequences of a sort of a very high risk watch list. Let's say you're looking for people with outstanding arrest warrants for violent felonies. The risk here is a misid, which is increasingly likely because of that variability and that inaccuracy. The consequence is somebody being maybe forcibly arrested or being held at gunpoint on the basis of that misid. So I would say it's just, and then mass collection just quite simply enables or will lead to chilling effects that individual collection may not. So I think when considering which controls to put in place, I would be very, very skeptical, both from an accuracy and a rights intrusion perspective on mass collection more so than individual.
Yeah, I would add a couple things to this. I would say that, again, some of this has to do with like thinking through how warrants are just issued in the United States. I mean, right now, law enforcement could get a warrant that says, give us and ask Google, give us all of the people that you have Google Map information on that were in this particular area at this particular time, right? Again, I would say that is a strange mass collection of information. I would also add to this that, and I believe it was Claire's team at Georgetown did some work on the way that state law enforcement agencies were trolling photo databases. And one of the states that were pulled in this was my home state, Utah, in the way that they were allowing out of state and even federal agencies such as ICE to just use the driver's license database to find, they have a picture of a person they're looking for, and they were essentially just letting law enforcement agencies out of state or federally just sort of have complete access to the database and run the facial recognition algorithms. I also think that there's an important piece here that we need to talk about, especially in this instance, is the response is not like this is a perfect match, right? Very rarely are you getting like 100% perfect match. You're getting like, here's the standard, like here's basically, we know within a certain probability that this may or may not be a match. And what you have found in law enforcement instances is that they're actually like, going with very low probability matches. So you get like several photos returned, right? You could say I'm looking for a person, and you can actually play games with the algorithms. I do think from a regulatory point of view, in terms of this, if you want to call it mass versus individualized surveillance, anything that could threaten someone's life or liberty needs to be taken very, very, very seriously. And I think that oftentimes law enforcement is playing a little fast and loose with these technologies. And it is having sort of a general negative effect, not just on the individual people, but on our ability to effectively use these technologies in the future, right? Our trust in the technology is going down because they're being abused by folks like this.
Thank you very much. So we have another question from the audience from Representative Sullivan. Not everyone wants to participate in the commercial applications of facial recognition technologies. She says, all I hear from industry is that we should do nothing to address this and let them continue to use it. And at the same time, some privacy advocates want a complete ban. Is there any organization working on a middle ground? And are there any advocacy groups willing to have this conversation, or are we simply in a place where we can't find any common ground? Not an easy question.
I think Claire and I have common ground. I mean, like, I don't think like we're really disagreeing that much. I like not to paraphrase her point, because she could speak for herself. But I do think it seems to me, at least in this conversation, that we agree that there should be strong protections when it comes to law enforcement and rights violating uses of this technology. To me, that seems to be a very common ground. I don't think there's anyone out there that would say we need to just allow like nascent, unproven technology to be used in a law enforcement and criminal capacity, even in the courtroom. I think that seems to be, everyone I talk to seems to be in agreement in this. Like the researchers, the folks that say leave it alone, the folks that say lock it down, like everyone seems to be in agreement in that. And I think that to me seems like very reasonable common ground, is that those are the protections that legislators ought to be focusing on.
I would agree, and I think the question is probably looking more at commercial applications, but I will say, yeah, there's a lot of agreement on the law enforcement side of things, which is interesting to me. It's also a very bipartisan issue. At the federal level, our largest allies were the late Representative Cummings and Representative Jim Jordan, these two individuals could not be further from each other on a lot of issues, but they were very much in agreement on law enforcement use of face recognition. On the commercial side, this is, again, less sort of my area of expertise, but I think the challenge is that, yes, people's talking points are further apart than, and industry groups versus advocates. Talking points might sound like they're not in alignment, whereas there probably is common ground if we look less at the technology itself and more at the maybe the industry in which it's being deployed. The risk of bias, I think there's general agreement, even in the commercial space, that we have to be pretty careful around deploying technology that just quite simply performs differently depending on who you are, on your race, sex, and age, and the impacts, instead of the technology itself, to look at what are the impacts. I'm going to go back to the hiring example just for a second. If we have I think this is one of the places where there is a lot of concern. It are the hiring algorithms basing decisions on are the inputs that they're analyzing and the outputs. Do they have a racial difference in what they're analyzing? And I think there's a lot of agreement, and it's a little hard to argue that we should allow algorithms to, even though humans are flawed algorithms should replace them. But yeah, I mean, it's a tough question, and I think it's really hard to cut through the sort of public positioning and posturing of a lot of advocacy groups and industry groups to get at sort of this common ground.
I would add to Claire's example, if I'm an employer and I use a technology that may have a racial outcome, and I use that technology to make a hiring decision, and so I make a hire or not hire decision based on their race, either intentionally or by default allowing the algorithm to do that, that's already illegal, right? That's already, like, that is already illegal. Like, you cannot make an employment decision based on race, sex, country of origin, like those. You cannot, you can't do that. It's already illegal. So I think if someone's using an algorithm or a facial recognition technology that has identifiable and provable racial disparities, they're violating the law. I mean, we already have laws in place, and I think that's like, to me, that's an important part in the debates around these technologies. Is oftentimes we want to regulate the technology specifically for an instance in which there's a generalized law that already covers these instances. I'm not saying I don't disagree with Claire. Like, no one should make those decisions, and no one should be using technology that, like, look, I'm the executive director of a nonprofit. If someone brought me technology and said it may or may not do this, I would throw them out of my office, right? Like, as an employer, you cannot in good conscience use technology in that way. And I think most of us, if many of you as state representatives are small business owners and others, like, it's incumbent on the user of the technology to also understand the capabilities of that technology, because ultimately you will be held responsible for what comes of it, as opposed to just saying it's the computer's fault. It's the person who uses it, it's their fault, right? And laws already cover this.
All right, well, we have about 6 minutes left, so I'll just give both of you a few minutes to talk about especially how legislators can deal with a field that is evolving so quickly. I know Claire mentioned technology neutral approaches earlier, but what do both of you think about trying to regulate something that is just constantly evolving? And then we'll go ahead and wrap up.
Yeah, so just very briefly on this, I have mentioned focusing more on the rights that we're seeking to protect, as opposed to the technology itself. I think that's a really important angle to future-proof this legislation, particularly in light of how rapidly developing the field is. I also think this is sort of a unique benefit of a state and local approach. State and locals can just act a lot more rapidly and effectively than the federal government, and have a more tailored approach to the needs and interests of your constituents and the realities on the ground. So I think that is a benefit of focusing on state and local action. And then the last thing I will say is I work for an organization that does advocate for a moratorium on the use of face recognition in a law enforcement context. This is particularly in light of two things. One is this disproportionate impact and the racial bias that still happens in a lot of these systems and we don't fully understand. And the other reason is I think the cases in which this technology is used, there may be a question where this technology has violated the due process rights of those individuals, and we have no idea how many wrongful convictions or wrongful plea bargains and whatnot have occurred over the last 20 years because of this technology. So for all those reasons, taking a step back and saying we need some time to figure out what the rules of the road are. We need to take some time and understand that this is a forensic science, and therefore we need to treat it as a science, not as magic, as a technology that any officer can use. We should maybe have trained individuals using it. I think there is a benefit to taking that pause and putting specific sort of next steps in place whereby we continue to investigate misidentification rates. We conduct audits. We increase the transparency around the use of the technology so that we just have a more comprehensive understanding of how it's used and how it should be used.
Yeah, I would say that I've already said this probably 30 times. I'll say it 31. I think for legislators, focusing on the true nature of the problems here, and I think Claire hits the nail right on the head. It's in these law enforcement and criminal instances in which most, if not all of us, are very acutely concerned about. And I would say beginning there is a great place for legislators to start. From there, I would say, again, if you're going to make a move in any sort of emerging technology space through regulation, you need to have a very clear statement of what the problem is and a very narrowly tailored response to that particular problem. I would say something like, again, look to an instance like BIPA, in which it's very, very well intentioned and is imposed in the name of privacy. But there are clear trade-offs to this, right? In Nest, the smart camera systems that many of us may have in our homes or on our doorbells are turned off in Illinois because of BIPA, right? The Sony Aibo, right? The robot dogs, which could help millions of people who are suffering from dementia as a complement to their current care, that's unavailable to people in Illinois, right? And in the other states that have followed this mode. So I would say there are clear trade-offs in this space. Neither of those technologies existed in 2008 when these laws were passed. So in some ways there was no cost because there was nothing lost, right? We were passing laws on technology that were decades away. As Claire mentioned, gate technology isn't for another 5 years, and yet we regulated it 20 years ago in Illinois. And I would say walking backward from there and saying, again, as the nature of the market and the technology changes, being willing as legislators to constantly and continually renew these things. So I would say any technology specific policy that is passed in a state should sunset, right? To set it on a 24-month shot clock, and it expires in 24 months and forces the legislature to reconsider the policies that they've instituted. I mean, that's just a really simple way to ensure that the policies that you're passing can be refreshed and renewed and focused on the real problems in the evolution in the technology in the markets, as opposed to taking a snapshot in time and forcing the future to be dictated by decisions we made decades ago.
Well, thank you both so much. I really appreciate your expertise, and this has been a really interesting discussion. Luke, at the beginning, put a link to our Privacy Week agenda, so you can go ahead and look at what else we've had this week and watch our recording of our consumer data privacy webinar from earlier this week. And again, we really appreciate both of your participation and all of the questions from the audience. We will have this recorded on our website within the week, so we'll send that out to you. So again, thank you so much for joining us. And if you have any questions, just reach out to any of the NCSL staff. And thank you for joining.
Thanks so much for having me, Abby.